International water law. The introductions to international water law, fragmentations of treaty practices, development of United Nations Watercourses conventions, legal frameworks and principles, case law, challenges and issues, historical evolutions, influence of treaty practice of United Nations Watercourses conventions, procedure and dispute settlement, the impact on regional and international practice, and conclusions. In 1959, the United Nations General Assembly began discussing international river management. Prompted by Bolivia, Sudan, and Egypt's exclusive Nile Agreement raised questions about global consensus and cooperations. Existing bilateral and multilateral treaties needed review to understand common practices. The United Nations General Assembly requested the International Law Commissions, the ILC, to study non-navigational uses of international water courses. A survey was conducted, including laws, treaties, and tribunal decisions, revealing a fragmented treaty landscape. The fragmentations in treaty practices present several challenges, including lack of uniform principles, regional disparities, and exclusions of key states, which undermine the effectiveness of these agreements. With regard to the fragmentations, there is a fragmentations identified in treaty practices. Lack of uniform principles. Existing treaties vary widely in their provisions, lacking consistent principles and rules. Regional disparities. Some regions had comprehensive agreements, while others had minimal or outdated treaties. Exclusion of key states. Critical upstream or downstream states were sometimes not parties to regional agreements, undermining their effectiveness. The 1959 agreement between Sudan and Egypt exemplify the challenges of fragmented treaty practices by excluding upstream countries. The agreement failed to consider the interests and needs of all riparian states, leading to ongoing tensions and disputes. The International Law Commissions, the ILC, developed draft articles for a global conventions aiming to codify existing principles and introduce new concepts. In 1997, the United Nations General Assembly adopted the United Nations Watercourses Conventions, providing a legal framework for managing international watercourses. The role of international law commissions is it undertook extensive studies to develop a set of draft articles that could form the basis of a global conventions. The objectives were to codify existing principles by consolidating established principles from existing treaties and customary international law, progressive development, which introduces new concepts to address contemporary challenges in international water management. In 1997, after years of deliberations, the United Nations General Assembly finally adopted these conventions, known as Conventions on the Law of the Non-Navigational Uses of International Watercourses, the UN Watercourses Conventions, which aim to provide comprehensive legal framework governing the rights and obligations of states concerning the use and management of international watercourses. The legal frameworks and principles. The first is equitable and reasonable utilizations obligations. States must utilize an international watercourse in an equitable and reasonable manner. Factors for consideration, such as geographic, hydrographic, hydrological, climatic, ecological, and other factors of a natural character, social and economic needs, populations dependent on the water course, effects of the use in one state on another state's existing and potential uses, conservations, protections, development, and economy of use of the water resources, availability of alternatives. With regards to obligations not to cause significant harm, state shall take all appropriate measures to prevent causing significant harm to other watercourse states. If significant harm is caused, the state responsible must take measures to eliminate or mitigate such harm, and where appropriate, discuss compensations. There is a general obligations to cooperate. States shall cooperate based on sovereign equality, territorial integrity, mutual benefit, and good faith by establishing joint mechanisms or commissions as deemed necessary. There should be regular exchange of data and informations. States shall regularly exchange readily available data and informations on the conditions of the watercourse, including hydrological, meteorological, hydrogeological, water quality, and related forecasts, and also notifications concerning planned measures. States must provide timely notifications to other watercourse states of planned measures that may have a significant adverse effect. Consultations and negotiations, because upon request, the notifying state shall enter into consultations and negotiations with the affected states. And also, states shall protect and preserve the ecosystems of international watercourses. Obligations States also have obligations to prevent, reduce, and control pollutions that may cause significant harm. Equitable and reasonable utilizations obligations not to cause significant harm, general obligations to cooperate, regular exchange of data and informations, notifications concerning planned measures, protections and preservations of ecosystems. There is a few case laws and examples that can be observed, such as the Gachikovo-Nagymaros project between Hungary and Slovakia. A dispute arose over the constructions and operations of dams on the Danube River. The case addressed the principles of equitable utilizations, environmental protection, and the obligations not to cause significant harm. The International Court of Justice, the ICJ, emphasized the necessity of cooperations and the importance of sustainable development. Another example is Indus Waters Treaty between India and Pakistan, a bilateral treaty governing the use of the Indus River system. It is significant because it is regarded as a successful example of cooperation, even amidst political tensions. Allocations of river waters, establishment of a permanent Indus commissions, and mechanisms for dispute resolutions is also part of the treaty. Some of the key challenges in water management include non-participation of key states, important states, affected states, fragmented regional agreements, and environmental and development pressures. These issues hinder effective implementations, create inconsistencies, and increase demand and risks due to climate change. Not all countries have ratified the United Nations Watercourses Conventions, therefore limiting its universal applicability. The absence of key upstream or downstream states hinder the effective implementations of these conventions. Regional treaties may lack alignment with modern principles of international water law. Some agreements focus narrowly on specific issues, such as border demarcations, rather than comprehensive water management. Growing populations and economic development intensify the demand for water resources. Altered hydrological cycles pose uncertainties and risks to water availability and management. Balancing developmental needs with environmental protections remains some of the most critical challenge. The non-participation of key states of United Nations Watercourses Conventions creates ratification gaps. It limits its universal applicability. Fragmented regional agreements, they often lack alignment with modern international law. It just focuses on issues like border demarcations and also environmental and development pressures. Climate change pose risks to water availability. The United Nations Water Courses Convention marks a major step in international water law. It promotes equitable and sustainable use of shared water resources. Its success relies on widespread ratifications and implementations. Effort should focus on enhancing cooperations, updating regional agreements, and address emerging challenges like climate change and pollutions. In 1959, the United Nations General Assembly, following a proposal from Bolivian government, it initiates discussions on issues such as utilizations of international rivers. This initiative aimed um, to explore the feasibility of codifying these issues at global level. The task was daunting, especially considering that in the same year, Sudan and Egypt entered into an agreement that allocates Nile's waters exclusively between themselves, excluding all other upstream Nile riparian states. It raised significant questions of global issue regarding water courses agreements. To address this issue, the United Nations General Assembly requested United Nations Secretary General to survey relevant sources. This include national laws, bilateral and multilateral treaties, decisions of international courts and tribunals, and the studies by non-governmental organizations. Water course treaties date back to 2500 BC. By 1986, there were around 3,600 treaties, mostly on navigations. Significant treaties include 1978 Great Lakes Agreement and 1980 Niger Basin Conventions. Challenges remain in Africa, Asia, and South America. North America has the most bilateral treaties. Africa has 64 international watercourses, but only 19 are covered by treaties. Asia has 57 watercourses with 24 treaties. South America has 38 watercourses with only 6 treaties. Europe and North America have much more comprehensive treaty coverage. The International Law Commissions (ILC) face challenge of creating a cohesive framework from fragmented treaty practices. The definitions of watercourse was contentious, with some states advocating for a narrow scope and others for a broader drainage basin approach. The latter influenced by Helsinki rules, was ultimately adopted, defining a watercourse as a system of surface and groundwater forming a unitary whole. The conventions is founded on two substantive norms. The first is equitable and reasonable utilizations, and the other is no significant harm principle. The ILC found support for these norms in existing treaties, but had to clarify their relationship. The convention requires states to prevent significant harm to other watercourse states, and also to determine the lawfulness of any harm based on equitable and reasonable utilizations. The conventions outlines detailed procedural rules for planned measures. It requires states to notify and consult with other watercourse states. It includes dispute settlement provisions encouraging negotiation, mediations, and arbitrations with a compulsory fact-finding commissions as a last resort. One of the convention's most important contributions, it was the establishment of procedural requirements for planned measures affecting shared watercourses. These procedures are based on broader obligations of states to cooperate in good faith, respect sovereign equality, territorial integrity, and mutual benefit. Article 8 of the conventions provides that states share informations, notify affected countries of planned activities, and consult whenever necessary. The ILC relies on existing treaty practices inform these procedural rules. For instance, the Statute of the River Uruguay between Uruguay and Argentina, signed in 1975, served as a model for the convention's notifications provisions. In this treaty, Uruguay and Argentina committed to inform each other of any planned measures that could affect the river, and they agreed on a structured process for addressing potential concerns. If consultations and negotiations fail, the convention outlines formal dispute resolutions mechanisms. Parties are encouraged to resolve disputes first and foremost through negotiations. If this process is unsuccessful, they can seek mediations or conciliations, resort to joint watercourse institutions, or submit the dispute to arbitrations or international court of justice. One of the features of the conventions is the establishment of fact-finding commissions, which either party can request if a dispute remains unresolved. Commission's findings are not binding, however, they carry significant weight and importance because parties are obligated to consider them in good faith. The United Nations Watercourses Conventions has significantly influenced regional agreements, like Southern African Development Community (SADC) in 2000, which established a protocol. This protocol replaced an earlier 1995 agreement, seeks to address challenges of integrated water resource management in that region. And also Nile Basin Cooperative Framework Agreement (CFA). CFA reflects convention's influence, especially in terms of equitable and reasonable use and no significant harm. However, CFA has faced obstacles, particularly with Egypt and Sudan opposing certain provisions, which highlights the enduring challenges of reaching consensus in politically sensitive water basins. In Asia, Vietnam's accessions to the conventions in 2004 triggered the convention's entry into force provisions. Vietnam accessions to conventions, it has triggered the convention's entry into force, partly motivated by its desire to strengthen the Mekong Agreement's provisions on notifications and consultations. Vietnam recognized that the convention's more robust procedural framework could complement the general terms of the Mekong Agreement, especially given China's upstream developments on the Mekong River. The United Nations Watercourses Conventions unify diverse practices in international water law by influencing regional agreements like those in Mekong and Nile basins. It has contributed to customary international law and laid the foundations for cooperative water resource management. The conventions also represent a significant step in progressive development of customary international law. This can be seen in the International Court of Justice case Gapchikovo Negimaros project decisions, where the court acknowledged the importance of environmental considerations in interpreting bilateral treaties. By embracing these efforts, the international community can now work towards the harmonious and sustainable management of transboundary water courses, benefiting both present and future generations.